Good afternoon. Mr. Luckman and I welcome you to another discussion of the great ideas. Today, as we continue the discussion of law, we shall deal with the problem of how human laws are made. And of course, we can only deal in discussion of how laws are made by man with those laws which are within man's power to make or not to make. As we saw last week, I think, not all laws to which men are subject are of this sort. Some laws are not made by man, but discovered by man. The natural law, as it discovered by man as he examines his own nature. Some are received by man, as the divine law is received from the revelation of God. Now, the two preceding discussions of law which we have had have direct bearing on today's problem. Our consideration of how human laws are made is certainly affected by the two deeply opposed views of what the human law is. Whether on the one hand, it is something grounded in the reason, or on the other hand, something that is merely imposed by the will of those who have the power to enforce law. It is also affected by the two views about how human law is related to the natural law, how the positive law is related to the natural law. The view on the one hand that the positive law is derived somehow from the natural law, as against the view that the positive law has no relation to the natural law. The view of those who deny that there is a natural law, or that if there is a natural law, it has any bearing on the making of positive law. The questions we have received as a result of these two preceding discussions may help us, may be very useful to us in starting off today's discussion. Lloyd, would you read one or two of the questions we have selected for that purpose?
Well, in view of the fact that you're going to consider the making of human laws, I think the most pertinent question is one that we have from Frank Milligan, who lives on Baker Street here in San Francisco. And he writes, "This is pure theory, of course, but if the Ten Commandments were adhered to and obeyed by all, would there be any need for additional laws?" Now, as I see it, Mr. Milligan is simply asking you to tell us why men make laws before you tell us how laws are made.
The why question, Mr. Milligan, certainly comes before the how question. But as I see it, Mr. Milligan, your very question contains part of the answer. It's all contained in that word if you use. If all men adhered to and obeyed the divine law. That's like saying, if all men were saints. It was like saying, as we saw when we discussed government, if all men were angels, no government would be necessary. But Alexander Hamilton knew that all men were not angels, and I'm sure you know, Mr. Milligan, that the supposition that all men are saints, that all men obey the divine law perfectly, is a supposition contrary to fact. And because it is a supposition contrary to fact, you have one reason for human law. Human law is needed because all men do not adhere to or obey the divine law. That, by the way, is the answer that a great theologian gives when he himself asked the question why it was useful for men to frame laws in view of the fact that God had given the Ten Commandments to men. Aquinas, in a question which is worded that very way, whether it was useful for laws to be framed by men, Aquinas says, since some men are found to be depraved and prone to vice and not easily amenable to words, it was necessary for such men to be restrained from evil by force and fear, in order that at least they might desist from evil doing and leave others in peace, and that they themselves, by being habituated in this way, might be brought to do willingly what hitherto they did from fear, and thus become virtuous. But that is not the only reason. In fact, it is not the deeper or deepest reason for the need for human laws. There is a deeper reason. Even if you could suppose that all men were to obey perfectly the Ten Commandments of the divine law, there would be a need for human laws. Let me see if I can show you that in two ways, Mr. Milligan. First, let's take the commandment, thou shalt not steal. But there are many ways in which men steal. There are many forms of stealing. Are they all equally stealing? Are there more serious stealings and less serious stealings? Should they all be punished in the same way? Questions of this sort are answered by the human law, not by the divine law. And then think of this fact, Mr. Milligan. The divine law, and as a matter of fact, the natural law, contains no traffic ordinances, no traffic regulations. And I'm sure whether you are a pedestrian or an automobile driver, you recognize the deep need for traffic ordinances. This is another reason for the utility of human laws over and above the divine law or the natural law, even if all men were to obey them both.
Now, if you'd go back from your discussion of Mr. Milligan's question to a discussion you had 2 weeks ago, when you said that Mr. Justice Holmes held a view of the nature of law which agreed with Ulpian and his view, namely that whatever pleases the prince has the force of law, or in other words, that law is the expression of power rather than of reason. Now, I think that argument or that discussion probably elicited this question from Mr. Pat Frayne. Now, Mr. Frayne is a special representative of the California Department of Justice with the office here in San Francisco. And Pat Frayne asks you to comment on the remark of Justice Holmes that law is not logic, but experience.
Mr. Frayne, as I remember the exact words Mr. Justice Holmes said, the life of the law has not been logic, it has been experience. And that reminds me of another statement by Mr. Justice Holmes, which is that in the study of law, a page of history is worth a volume of logic. Now, Lloyd, both these remarks are quite true. They are true in part. For certainly, the growth of the law is not a pure work of the reason. It does develop out of our social experience. It is perfected by our efforts to live together successfully and effectively. And certainly it is true that to understand the concrete details of the law as it is today, we must look to history. Pure logic will not explain the law. So far, Mr. Justice Holmes is correct. But I would think he would be wrong if he is taken to mean, or if he means, that logic, the rational aspect of the law, is totally irrelevant to its substance. Now, both these two questions, the one from Mr. Milligan, the one from Mr. Frayne, lead us into the very heart of today's discussion. And I think they will be answered more fully as we now examine the making of human law. Hence, Lloyd, would you postpone the other questions until we go a little further? Now, as I said at the very beginning, the two preceding discussions have a direct bearing on the problem we are facing today about the making of law. And I'd like to remind you of that background for today's discussion by showing you a series of charts which will remind you first of the two views of what human law is and of the two views about how the positive law is related to the natural law. I think you will see in these two charts, in these two or three charts, those relations sufficiently clearly for us to use them as we go on. Let's look at this first chart together. In this first chart, there are three distinctions. There is, first of all, the natural moral law itself, and then two views of the positive law. The view of the positive law as rationally grounded in the natural law, and the view of the positive law as having no relation to the natural moral law, but the positive law as simply willed and enforced. As I talk about this, let's regard this as the naturalistic view of the positive law, and let's regard this as the positivistic view of the positive law. Now notice, the natural law is to be regarded as nothing but an expression of reason itself. At the other extreme, the positive law viewed from the positivist point of view is simply something imposed by the will and has no relation to reason. Whereas the positive law, when it is seen as rationally grounded in the natural law, is seen as something which, though grounded in reason, must be instituted by will. Let's look at a second chart now. Again, the same three things, the natural moral law and two views of the positive law. The natural moral law consists of the principles or standards of justice. At the opposite extreme, the positive law, viewed as a positivist views it, as something simply willed and enforced, is to be regarded not as just or unjust, but merely as more or less expedient. Whereas the positive law, viewed from the naturalist point of view, as something grounded in the natural law, is both more or less just and more or less expedient. Finally, let's look at these three things in terms of how they bind or demand human obedience. The natural moral law binds men in conscience only. At the opposite extreme, the positive law taken from a purely positivist point of view binds by coercive force alone. But if you look at the positive law, not in that extreme way, but as something rationally grounded in the natural law, you see that it binds in conscience as well as by coercive force. Now, I'd like to make 3 comments on what these charts show. First of all, you can see that the view of the positive law as something, though distinct from the natural law, something grounded in it, puts it in the middle between the natural law at one extreme and the positive law looked purely as positive law at the other extreme. Let's look at this chart once more. This will illustrate the point. At one extreme, you have a law which binds in conscience only. At the other extreme, you have a law, the positive law, viewed from the positivist angle, which binds by coercive force alone. Whereas the middle ground, the middle position, that view of the positive law as somehow derived from the natural law, binds in both ways. As the natural law binds, it binds in conscience. And it also binds as positive law binds by coercive force alone. My second comment is that I may have given you a misimpression last week when I compared the positive law with the natural law. For in that comparison, I used a conception of the positive law, which is this middle position with respect to it, this position which sees it as something derived from the natural law. A much sharper contrast between positive law and natural law is made from the positivist point of view, which looks at the positive law as something unrelated to, unconnected with the natural law.
What you've just said, Dr. Adler, I think explains then this question we had from Father Frank J. Buckley, S.J., of the Bellarmine College Preparatory in San Jose. Father Buckley asks you, how can the state enact positive laws which do not bind in conscience? If the very nature of law involves the common good, it seems to me that from its connection with the common good, each law then binds in conscience.
It depends on which view of the positive law you take, Father Buckley. My guess is that you take the view that I call the middle position, that view of the positive law which regards it as derived somehow from the natural law. And if you take that view, then you think of the positive law as being made for the common good and as binding both in conscience and by coercive force. But on the opposite view, which is the one you are disregarding for the moment, the view of the positive law as unconnected with natural law, the laws bind by their coercive force alone. For they have the force of law, whether or not they are for the common good, whether or not they are just. Now, my third comment on the background we have just covered is this. On the extreme positivistic view of the positive law, there is no problem about how human laws are made. The only condition needed for the making of human laws is the power to enforce them. It is only on the other view, which regards the positive law, man-made law, as somehow derived from the natural law, that we have to face the question, how is it derived from the natural law? How, in the making of human laws, are these rules derived from the principles of the natural law? And that is the question I am now going to attempt to answer. And as I start to answer this question, I'd like to feel that you all shared with me, at least for the purposes of this discussion, a certain supposition. I'd like you all to share with me the supposition that the traditional statement of the first principle of the natural law, the first precept of the practical reason, is a correct statement of it. It is sometimes stated, seek the good and avoid evil. It is sometimes stated, do good, harm no one, render to each man what is his due, what belongs to him, what is his own. Now, the question is, from this first principle, this most general rule of conduct, how are other or further rules of conduct derived? The answer seems to be in 2 ways. First, by deduction. Second, by determination. Let me illustrate these 2 ways. Any thinking man, considering the command, harm no one, can certainly conclude that he should not steal what belongs to somebody else, or that he should not kill another man, take his life. The conclusion that killing is wrong, or that stealing is wrong, is a conclusion that any man can reach for himself. It's a simple deduction of the reason from this first principle, harm no one, or leave each man in the possession of what belongs to him. And these rules, kill no one, steal from no one, are often called, therefore, the secondary precepts of the natural law. Now, how do we go further than that? How do we go beyond these secondary precepts? Not by deduction. In this sense, Mr. Holmes is right. Logic will not do it. But by determination, by making those secondary precepts like thou shalt not kill, thou shalt not steal, much more determinate. To explain this to you, I'm going to go to the Penal Code of California. In the Penal Code of California, we find a whole series of sections dealing with various kinds of stealing. For example, robbery is one kind of stealing. It is not the same as burglary or housebreaking. That is not the same as forgery and counterfeiting, nor are either any of those the same as simple theft or larceny, either petty larceny or grand larceny. And those are still different from embezzlement and from extortion and from fraudulent transactions or cheats. There's a whole series of particular different kinds of stealing which the Penal Code of California defines. And by defining these different kinds of stealing, it adds determinations to the rule of the natural law which says thou shalt not steal. Now let's look at one section of the code together. Let's look at the section which deals with robbery. Here, as you look at this, let me read to you the definition of robbery given in the Penal Code. It says, robbery defined. Robbery is the felonious taking of personal property in the possession of another, from his person or immediate presence, and against his will, accomplished by means of force or fear. Now, that is something which man-made law adds to the natural law. And if you were now to look at the rest of the section, let's go back to that code for a moment, and look at what the rest of the section on robbery includes. That small type there, which I'm going to read to you, the first section is robbery defined, and then it goes on to talk about degrees of robbery, the kind of fear which may be an element in robbery, and the punishment for robbery. In fact, if I now go to the code and read those sections to you, you'll see that the degrees of robbery are first and second degree robbery according to whether or not a deadly weapon is used in the attempt to commit the theft. If it is not used, you have second degree. And then the punishment is defined or determined. Robbery, it says, is punishable by imprisonment in the state prison as follows. Robbery in the first degree for not less than 5 years, in the second degree for not less than 1 year. In other words, what you see from this example is the determination of the kinds of stealing on the one hand, and the determination of the particular modes of punishment for these different kinds of stealing. These two kinds of determinations are the way in which the human law adds something to the natural law, and the way in which the human law is derived from the natural law. Notice one other thing. The Penal Code does not say to anyone, do not steal. It merely defines the kinds of stealing and attaches to each kind of stealing a particular degree or grade of punishment. Now that's very important, because it's almost as if the Penal Code left to a man's conscience the knowledge of the fact that he should not steal. The natural law says do not steal. The Penal Code merely defines the kinds of stealing and determines the particular kinds of punishment for each of the different kinds of stealing. Now, what I've just showed you in terms of stealing is equally true of all other aspects of the positive law. If I turn now, and I don't have the time to do it in detail, if I turn now to the law of homicide, you would see that the natural law commandment, thou shalt not kill, is then broken down into a series of definitions of murder in the first degree, murder in the second degree, and the various kinds of homicide, and all of these distinguished from lawful killing or excusable killing under extenuating circumstances. And it isn't only the criminal law that does this. For example, take the vast body of the civil law, which is the civil law of contracts. That whole body of civil law dealing with contracts between persons and corporations consists of determinations of one principle of the natural law, a principle which you understand to be keep your promises. For if you fail to keep your promises, men who rely upon them, others who rely upon them will be injured. The law of contracts, the civil law of contracts, consists of the determination of under what conditions contracts are to be relied upon, how are they to be made, what are the penalties for breaking contracts. All of that is a set of determinations of the simple principle, keep your promises, which is a principle of the natural law. Now, I think you can see, in terms of these examples, that the principles of the natural law are like the invariant universal principles underlying all the particular determinations of various codes of civil law. For the law of California is different in some respects from the law of the 47 other jurisdictions in the United States and from jurisdictions abroad. And I think also that you can see how this answers a question raised, I think it was last week, Lloyd, by Miss Lucille McGovern, when she asked about the relation of ethics to law. She was asking, what is the moral content of the law? And the answer to that question, Miss McGovern, I think I can make clearer now than I did last week. For the moral content of the law comes from these principles of natural law that lie under the determinations that are made by the positive law. The determinations made by the positive law are things that are themselves indifferent. Different states can determine what burglary is, what robbery is, what counterfeiting is, what embezzlement is, and assign different amounts of punishment to it. That is not moral. That is practical or expedient to be judged in terms of how it works. But that robbery or stealing should be prohibited, and that stealing should be punished, and that different degrees of stealing should be punished in proportion to the severity of the offense or the gravity of the offense. This is part of justice. This is the moral aspect of the positive law.
I have a question right here, Dr. Adler. What about such things, for example, as traffic laws? What in the world is intrinsically right or wrong about driving on the right-hand side of the street or on the left-hand side of the street? How are such rules, then, as traffic laws, determinations of basic moral principles, I guess, is my question.
True, Lloyd. There is nothing practically, intrinsically right or wrong about traffic rules. Moreover, there certainly have been, and there are right now, primitive societies which don't have any traffic regulations at all. That's important to remember, because though there are primitive societies which have no traffic regulations at all, there probably are no societies in the world today, primitive or civilized, and never have been, which do not have some regulations against killing, some regulations against stealing. So that you see the traffic rules are of a different sort. They aren't necessary. Yet, under certain contingent circumstances, such as a complicated society which has automotive traffic and vast municipalities, traffic regulations under these circumstances are grounded in reason and have some relation to the common good. Because certainly the first precept of the natural law commands us to do whatever it is necessary to do for the safety and security and the welfare and the peace of the community. And in a society such as ours, traffic regulations are indispensable to the safety and security of the community as a whole. Hence, I would answer Lloyd by saying that while it makes no difference whether the traffic is required by law to keep to the right or to the left, that's indifferent. It does make a great deal of difference to all of us that traffic be regulated one way rather than another, and that there be some determinate manner in which traffic is organized and regulated.
With that, I agree.
Now, I would like to turn to one remaining problem. That is, we have time to discuss with regard to the making of law. It has to do with the source of the lawmaking power or authority. Now, anyone, as I pointed out before, can conclude that murder is wrong or that stealing is wrong by his own reasoning from the first principle of the natural law. But not everyone can make these determinations as to what robbery is and what burglary is or what the traffic regulation should be. Whence comes the authority and power to make such regulations, such determinate rules of law? The answer is that it either comes from the whole people or from the people's delegates or representatives. Now, there are two sorts of law that are made by the people as a whole. The first sort are customs, the established customs of the people, which have the force of law and even sometimes can abolish law or bring about changes of law. And the second kind of law made by the people as a whole is what we call constitutional law. The primary law of the land, which in fact sets up, creates, and circumscribes the law-making and law-enforcing power. You all, I'm sure, remember pictorially the two great episodes in our English and American history. The first, on the first occasion of such a charter being formed, you have a picture here of the barons of England, the nobles of England, eliciting from King John a charter of their fundamental rights concerned with trials and punishments and how law shall be made. And then centuries later, You'll remember the picture in Philadelphia of the last moments of our own constitutional convention, when the delegates assembled, finished the Constitution, which was then to be submitted to the people for the ratification. Such law, as you can see, is made by the people as a whole. They must ratify these laws. They are the constituents. And such primary law underlies the law-making power of legislators, and the law-applying power of judges, and the law-enforcing power of police officers. Now, according to this understanding of how law is made, a law is a law in name only if it fails to satisfy two conditions. First, it is a law in name only if it is not properly derived from the natural law in one of two ways, either as the law of homicide or larceny is derived from the natural law, or as the traffic regulations are. And second, it is a law in name only if it is not made in the right way, either by the whole people or by their representatives having duly constituted authority. Now, the most important point I can make is that the second condition by itself does not ensure the justice of the laws. For the will of the majority can often be as wrong as the will of a despot or a tyrant. Hence, we must face the question, which we will deal with next week: what is the ultimate standard of justice in the law? What determines when the law is not only rightly made, but just in content? And this is the problem I hope we can spend our last session on law discussing. We shall deal not only with the main question of the justice of law, but of the connection of justice and equity, and how laws can be improved, how there can be a progressive perfection of the law in the direction of more and more justice. These are the questions we shall discuss next week, and I trust you will send in all of your questions on justice, equity, and the improvement of law. Thank you very much.